An administrative decision is invalid if the decision maker fails to take into account relevant evidence. But what does this mean in practice? Exactly what does the decision maker have to do? In this case, a number of parties had made an application for a new radio broadcasting licence in Newcastle. The tribunal was required to consider, in relation to each applicant, the effect on market concentration if they won the additional licence. Specifically, the enactment said that they had to consider the need to avoid undue concentration of influence, whether direct or indirect, on the person and on the company or companies holding the other licence or licences. In practical terms, what this means is that the government did not want one ownership group dominating the radio waves in any particular market. So, all else being equal, more diversity of ownership would be better than less diversity of ownership. The winning bid in this case was a station which was to be partly owned by the Triple M network, which in turn was about to be purchased by Hoyts, and also partly owned by the Australian Labor Party, which has a long history of involvement in radio networks, and which already owned another radio station in Newcastle. So you'd have to say it wasn't unreasonable for the losing bidders to argue, as they did, that if the tribunal properly considered the issue of market concentration, they wouldn't have awarded the licence as they did. There's a problem with this though. Courts are not able to review the merits of an administrative decision. They can only review if it was made lawfully. And if you're arguing that a decision didn't take enough account of the evidence, such as the evidence of media concentration, you're really asking the court to undertake merits review. And this the courts will not do. In order to avoid this conundrum, the court's view is that as long as the decision maker takes any account at all of the relevant evidence, they've done enough. Justice Wilcox said, although the tribunal's explanation of its thinking in respect of undue concentration of influence leaves much to be desired, there is just enough to show that the tribunal did not overlook this matter. From this case, we learn that even the slightest consideration of relevant evidence means that the decision will not be invalid for the failure to consider that evidence.